Matter of Hoffman versus New York State Independent Redistricting Commission. Counsel?
Thank you, Your Honor. Mishat Saitlin for the interveners. I'd like to reserve 5 minutes for rebuttal.
Yes, sir.
In Harkenrider, the Steuben County Supreme Court adopted a remedial map under this court's order, which was so fair and lawful that no one even appealed. New Yorkers throughout the state understood that that map was the end of the congressional redistricting cycle for this decade, consistent with the anti-gerrymandering amendments prohibition against mid-decade redistricting. Yet petitioners asked this court to repudiate Harkenrider, the prohibition against mid-decade redistricting, not to mention the standard 4-month limit for bringing mandamus actions, all in the cynical service of giving the legislature a shot to enact another gerrymander. But if petitioners prevail, that inevitable gerrymander will be challenged in court again, will cause more confusion, and will cause embarrassment to the state of New York and its courts for launching the unnecessary fiasco that will follow.
What issue did the Harkenrider court address?
Sorry, Your Honor?
What was the issue or the question that the court answered in Harkenrider?
Right, so with regard to the remedy, once the court had found that the IRC and legislature had violated the constitutional process, the court had to decide whether it was going to order a legislative remedy or a judicial remedy. And this is what the court said in just 2 straight sentences. The procedural unconstitutionality of the congressional and Senate maps is at this juncture incapable of legislative cure. The next sentence, the deadline in the Constitution for the IRC to submit a second set of maps has long passed. So that was the clear, unambiguous holding of this court in Harkenrider. And this court would have to repudiate that remedial holding.
Doesn't that quote indicate that the court was focused on the timing of the next election, and here we don't have that kind of pressure?
With respect, the sentence says the deadline in the Constitution for the IRC to act has passed. It does not say the
Yes,
deadline.
at this juncture.
Yes.
That juncture. We're at a different juncture.
No, at this juncture was the prior sentence. And then the second sentence explains what this juncture is. It doesn't say that the primary is too soon. And that wouldn't have been a sensible thing for the court to say anyways, because the court, in its opinion, contemplated an August primary. Certainly, there was plenty of time in April if the court wanted to order the IRC to submit a second round map for the legislature to consider that map and to adopt it if it wanted for an August primary. There was plenty of time for that. And this court, I think, would have clearly said that if that's what it was intending.
Can we start back? I'm sorry, go ahead.
Was the focus in Harkenrider the unconstitutionality of the legislature's 2021 remedy, both procedurally and substantively, or was it the focus on the IRC's failure to act?
As I could tell from the questions that I got from this court last year at oral argument, once the procedural constitutionality had been found, the focus in that passage was, what are we going to do about it? And there were questions from this bench about whether it should be sent back to the IRC. There were questions about whether it should be a hybrid solution where the 2 IRC maps that had been proposed in the first round should be brought back up with a 2% limit. And as I read that passage, the court rejected those alternatives and said that the proper solution under the Constitution is a judicially adopted map. But even if your honors disagree with my understanding of Harkenrider, there are still 2 predicate issues here that were not decided in Harkenrider that would cut this lawsuit off from the beginning. One is that my friends simply missed their 4-month deadline to file a mandamus petition. Under 2017 CPLR, everybody knows, you want to file a mandamus action, you got to file within 4 months of accrual.
When do you think that clock started? What's your date on that?
Sorry?
When do you think that clock started?
Our position is to start on January 24th, when the IRC said that they weren't going to comply with their constitutional duties.
That was a few members of the IRC who said that, correct?
Right, but I believe that if a mandamus action had been brought at that point and said, look, the IRC, those members are saying it's not going to happen, I don't think any Supreme Court in this state would have said, it's not ripe. But in any event, if I'm wrong about that, even if it's the fact that it was only the 4 members, the next day.
Let me ask you about that.
Yes.
How does the presence of the, at that point, still not declared unconstitutional gap-filling statute affect what you just told me about mandamus?
It wouldn't have affected it at all, Your Honor.
So let me cycle it back then a little bit. Suppose the constitutional amendment that failed, right, in 2012, had actually passed. In that circumstance, could you have mandamus somebody, January 28th, let's say?
I don't have the specific wording of that amendment in mind, but I believe you still could have, because I don't think the amendment said the IRC's obligation is no longer mandatory. What I believe the amendment said, if it was the same as the statutory language, was if this violation happens, then the legislature has an additional option. I think
That's the question. Does that then render the obligation of the IRC not mandatory, not the sort of thing you can reach by compulsion? Because if the IRC doesn't act, the statute, or in this case, the Constitution, would have provided a different option.
Well, it was not in the Constitution, but in any
Correct.
in any event, no, because it would have had to have been worded a different way. It would have had to tell the IRC you don't have that shall obligation. And I think there was a lot of disagreement among everyone in Harkin Rider, but I think one thing everyone agreed to, and this was in footnote 9 of the opinion, and this was, I think counsel for the Assembly said this, is that the IRC violated its constitutional duty. And regardless of whether what the legislation had purported to do.
Let's stay there for a second. Would you agree that the preferred method under our Constitution is for the IRC to create maps?
Absolutely, Your Honor.
Go ahead.
And then what Section 4E does is it says the IRC legislature process shall govern, but if it doesn't, then the court's got to step in. And then the second sentence, Section 4E, says that plan, regardless of whether that's an IRC legislature plan, which is the preferable one, or the judicial plan, shall be in place for the decade unless modified by court order.
So 4E says that the court has to, it doesn't quite say has to step in, but to the extent that a court is required.
Mm-hmm.
So does that have any bearing on the temporal nature of what the court can do?
So the first sentence doesn't talk about any temporal nature. It just says, if you're required to do it, you got to do it. This court in Harkin Rider determined that it was right to do it. The temporal nature comes in the second sentence.
The first sentence of E is what I'm talking about, which says that the court, if essentially, except to the extent that a court is required to order the adoption of a plan, et cetera. So what I'm asking is that constitutional provision could have been written to say, except to order the adoption of, but instead it's written except to the extent that a court is required to. And so then the question is, if the preferred method in the Constitution is the IRC process, not a judicial process, and I think there's Supreme Court law from a long way back up to the present saying this is not a judicial function except if we're in extremis, right? Is there a plausible reading, let's start there, of to the extent that a court is required to place a temporal restriction on what the court can do? That is, if there's an exigency for an upcoming election, then something is necessary, but if a 10-year order from the court is prohibited, arguably, by this provision. Is that colorable or not colorable?
It's not, if that was the only sentence in 4E, perhaps it could be colorable, but it's not colorable with the addition of the second sentence, which says that plan refers back to the first sentence plan, is in place for the decade. And so it would have been you would think that if the people.
Well, there's a way to read the second sentence differently, I think, which is that the portion under unless, unless modified pursuant to the court order, exempts a plan that is modified by court order from the 10-year requirement, the first part of the sentence.
Well, right, Your Honor. So there's two problems with using that as a basis to justify what they have brought here. First of all, I think inherent in the structure of the first two sentences is that the fact that the map is court ordered under the first sentence can't be the justification for the modification, because then the court ordered plan under the first sentence is not given equal dignity with a.
Well, that's the point, is whether it's supposed to be given equal dignity. If you read to the extent a court is required, perhaps it's not, and there is, I think you acknowledged by nodding, although maybe I should get a yes or no on the record, that there is a lot of U.S. Supreme Court law saying that judicial creation of districts is not favored. Is that fair?
It is fair to say that at the federal level, the preference is for judicial solution, for a legislative solution. However, What had occurred
I'm sorry, when you say at the federal level, that's as a matter of federal constitutional law.
in the matter of federalism with regard to the interaction between the federal judiciary and the states. But what had happened and what the people had seen is, especially in the infamous Texas mid-decade gerrymander that Tom DeLay engineered, was that mid-decade redistricting is particularly dangerous because, of course, the potential gerrymanders know where the incumbents are, know where the close districts are, and know how to take them out. And so what the second sentence of 4E provides is we're going to take that off the table in New York. If the people wanted to preserve the option for mid-decade redistricting, when you have judicially drawn map, they would have said that. And while the type of breakdown in the IRC process that occurred last year may have not been top of mind to the people, the potential for a deadlock during the IRC legislature process was obviously top of mind. 2 years before the amendments were adopted, there was a deadlock within the legislature such that a judicial map had to be adopted at the federal level. And that kind of deadlock is quite common in New York and other states. So if the people wanted to have a prohibition on mid-decade redistricting that only applied to IRC legislature maps, that's what they would have said. But I don't think it's a fair, yes, Your Honor.
Counsel, this question about the federal courts. The federal court, Supreme Court, has basically thrown up their hands here on political gerrymandering, right?
That's right, Your Honor. In the Ruccio case, they said that's not a federal issue.
So this is really uniquely a state and state court, state legislature issue now.
That's exactly right, Your Honor. And what the people did in adopting the anti-gerrymandering amendments, not only did they set up an exclusive process and a prohibition against partisan gerrymandering, they also concluded in the second sentence of 4E that mid-decade redistricting is particularly dangerous, a particularly dangerous ground for partisan gerrymandering for the reasons that I said, and that's why they prohibited it. All they allowed was a modification.
Let's go back, I'm over here. The language of 4E, right? The court is authorized to come up with a remedy for a violation of law. So let's say, just for purpose of this question, that we disagree with your view about what violation Harkenrider was addressing. Let's say we view the remedy and the violation that the remedy that Harkenrider adopts and the violation that Harkenrider identified, violation of the law, is the legislature acting pursuant to a law that it enacted as opposed to the Constitution, which the majority decided was counter to the commands of the Constitution. If that's the violation, then getting back to the Chief Judge's question, then isn't this really about the modification? That's the violation you're addressing, and the plan you came up with is a plan you came up with to remedy that violation, and then the modification is one to make clear that you have now addressed that violation.
Well, I have
You got a different
I
violation.
still think the same two answers I gave to the chief would apply, and I've talked about the first one a little bit, which is that the court adopted plan has to have equal dignity. But I'd like to talk about the second, which is that it has to be a modification. It can't be an adoption. Adoption is what's allowed under the first sentence. Under the second sentence, it has to be a modification. And for something to be modified, something else has to be adopted.
Let me ask you this.
Adoption.
Again, if we disagree with you on the violation that's being cured through Harkenrider, and that plan exists for a temporary period of time, isn't the plan that's in place then the prior plan, which is not in accord with the Constitution, and as a consequence, you're then modifying that plan?
Well, that plan was also invalidated in Harkenrider. I think it was our.
Well, where are we left? If we disagree, again, we disagreed with you. All we were doing was correcting the violation of what the legislature had done. That's the correction, and the remedy was temporary only for that. Then is it that the state has no plan in place, or we're left with the prior plan?
Well, my legal position is that the courts have no authority to order interim maps under the second sentence of 4E. But certainly you'd be left in kind of a constitutional no man's land because there isn't any prior map. That map, the favors map, was also invalidated in Harkenrider as
That's all I'm
violating
saying. Isn't it then a modification of the map that we've recognized is not valid?
The legislature's gerrymandered map that was.
No.
Issue?
No, because that map, as I say, sunsets, right?
yes.
Because you've got a particular remedy in Harkenrider.
Yes.
Is it possible to view it that way?
I apologize, I'm confused. There's three maps you could be speaking about. There's the one was adopted by a federal court in 2012.
Yes,
That was invalidated by Harkenrider.
yes.
There's the map that the legislature adopted in last year. That was also invalidated by Harkenrider. And there's the court-adopted map.
Right, and my point is, if we disagree with you about the temporal limits of the map that is adopted and approved by Supreme Court post-Harkenrider, in accordance with the commands of Harkenrider, what would now be in place?
There would be no map at all because every map would have been validated. I believe the 2000 map was invalidated by the federal district.
So then, what would prohibit the court from addressing that particular problem? That violation of law, that being that now there's no map in place, and that's your violation of the law. There's no valid map in place. Is the court not able at that point?
That's going pretty far down the funnel, Your Honor. I think that my friends have framed their case as a request to modify the Harkenrider judicial map. That's how they framed their case. And then the question, if Your Honor gets down that, is are they asking for a modification?
May I just ask another question
Yes.
at that point? You've already agreed that these plans have a strong preference for the IRC. It was never contemplated that the IRC wouldn't present a plan. So in 4E, it presupposes that the IRC has submitted a plan to the legislature. That's what it's talking about when it talks about this 10-year plan. So we have no plan at all, which is where we've arrived, which is why we're here.
I strongly disagree with your premise of your question, Your Honor. The first sentence of 4E certainly contemplates a potential for a breakdown of the IRC legislature process. That's why it allows for the judicial adoption of a plan. Now, maybe the people had more in mind a breakdown within the legislature, but the structure of the argument would still be the same.
There's nothing in 4E that says that requires a particular type of plan or that there has to be a plan or anything else with regard to what the court can require.
I mean, I understand that that's what the Nichols court held, but I strongly think that and this was our third argument, the one I started off with, my read, Harkenrider, is saying that once the constitutional deadline for the IRC has passed, the only permissible remedy is a judicially adopted map. I know Your Honor disagrees with me, and that was the holding of Nichols, which is why we have the other two arguments that we do.
When does section 5B(a) apply, if at all?
It does not. That section permits calling the IRC back in, calling an IRC back into effect, and I agree with the League of Women Voters, it would have to be a newly constituted IRC based upon whoever the majority leader and the minority leader were at the time, to help the court in amending the map. That clause of 5A does not allow for a relaunching of the IRC legislature process. I think it would allow if there was some problem adhered in the current map. For example, it didn't have a Section 2 VRA majority-minority district, then the court could call back an IRC, a new one that the current leaders would appoint, and then that IRC would tell the court, this is the new map that should be adopted that would have the additional majority-minority district, and the court presumably would adopt that map. Nothing in that constitutional provision allows for a relaunching of the specifically time-limited sequenced IRC legislature process. It just requires the IRC to be brought back in. So if Your Honors think that that is the provision they're using, then what needs to happen is a new IRC needs to be called, and they need to submit a single map to the court, and then that would be the map. Now, we think that's all wrong. We think that the Harkenrider map should take place, but nothing in...
With respect to the citizens of the state of New York amending the Constitution to require an IRC process, how did they get that from the Harkenrider decision? Was the IRC involved in the map that ultimately was used?
No, there was a breakdown in the IRC legislature process, and obviously, Your Honor...
So is it ever going to, how does it function, if at all?
Well, I think that given Harkenrider and a robust enforcement of the constitutional provisions, in 2030, there will be every incentive for for the legislative leaders to appoint IRC commissioners that will do their job, and for people who are unhappy with what the IRC is doing.
But doesn't that encourage the kind of conduct that happened here? Gaming the system, of blocking the process by members who are dissatisfied with the way other members are drawing the districts?
Well, so
How can that be what the people of the state of New York want?
footnote 10 of Harkenrider addresses that and said the way you solve that problem is with a mandamus petition. And the way mandamus petitions work in the state is you have to bring them timely, within 4 months. You don't wait for 5.5 months to see if the judicially drawn map is to your political favor, to see if your little gambits in federal court, to try to overrule this.
And of course, that footnote that you're talking about is indeed in a case where the majority is deciding the state legislature took action that it could not. That footnote can be about moving in the future, now that Harkenrider's majority says that the state statute and what the state legislature did is unconstitutional or violation of law.
Obviously, the judges of this court know what you all meant in Harkenrider. I'm sure you all discussed that in your conference. But nothing about that uncertainty, which sure is knowable to you all, at all impacts the plain as day 4-month statutory limit to bring in a mandamus action, and nothing in that discussion impacts the very clear prohibition against mid-decade additions.
What is your response to the invitation to convert this particular action?
Well,
Avoid the statute of limitations problem.
I think there's a couple of problems with that. First, mandamus is the proper tool to get a body to act in a mandatory manner. That's what mandamus is for. And the only reason that I think the governor is suggesting this is to evade the 4-month limit. But the 4-month limit makes perfect sense here. You don't want folks sitting on the sidelines seeing, do we like the map? I mean, under their theory, someone could have waited until the 2022 elections. Okay, well, too many Republicans won close congressional districts. Now I'm going to bring that kind of action. I think funneling it through the natural mechanism, which is the mandamus mechanism, with a tight time limit, makes all the sense in the world. I think the mischief in allowing parties to wait.
But what if the people that you're referring to, the claimants, are saying, boy, there's a statute in place, and that might address the fact that the IRC has not acted in accordance with the Constitution, and until a court says that the state couldn't do this, I don't have an action.
I don't believe...
Because I don't have an action to command something that a court might say is not what the IRC must do.
I do not believe that anybody in Harkenrider was suggesting that the legislation lifted the IRC's unconstitutional duty. I think it was common ground among all the judges who asked questions about it and all the advocates that the IRC had done wrong, regardless of whether the legislation was constitutional.
All I'm saying is the claimants here don't know that until the court announces that.
Nobody, I think there's no one that was disagreeing that the IRC had blown its deadlines and that those were still mandatory.
No, but I think the question is, was there an understanding at the time Harkenrider was commenced, when it was being litigated, or maybe even before, that mandamus relief was available for the violation that we're talking about?
I don't think that there was any dispute that if a mandamus had been brought on January 24th or 25th, that anyone would have even argued, let alone succeeded in arguing, that that mandamus petition was premature.
Well, but you think that would have been timely even if it was brought, let's say, April 1st, I think, right?
If it was brought April 1st, 2022?
Yeah.
It would have been timely for mandamus purposes, but it would have had, I think we would have still had our latches argument that that they shouldn't have waited that long. But yeah, for purpose of the 4-month limitation, that would have been within the 4-month limitation. We would have said you sat on your rights unnecessarily. And you should have brought it
Latches
early.
requires prejudice to you, no?
Certainly, we having brought and obtained a map that we think is fair.
By April 1st, you wouldn't have done so, in my hypothetical.
We brought our lawsuit early February.
Yeah, but you wouldn't have had a map.
That's
You
true.
wouldn't have a
We would've-
decision,
we
you
already
wouldn't even
won.
have a decision from us by then.
That's true, but we would have won, in the Supreme Court.
That's cognizable prejudice for latches?
Well, in any event, that hypothetical is in April. By
Okay, but-
June 28th, then we had our maps.
Let me ask you something different.
Yeah.
What is your understanding of the basis on which we held the gap-filling legislation unconstitutional in Harkenrider?
That the Constitution says shall, and that provides the exclusive process for adopting redistricting maps in the state. That when the legislature purports to act, when it has not received a mandatory submission, it has taken a step that it has no constitutional authority to.
So what would have been the circumstances, maybe what Judge Rivera was asking before, and I just didn't follow the answer. What would have been the circumstance if the gap-filling legislation didn't exist, the RSC did exactly what it did, and the legislature did nothing, and the 28th of February rolled around? Could the legislature have done anything at that point?
No, and this is something that we just did discuss last year. If nothing had happened at that point, then the only map in place would have been the favors map from 2012, and then we would have had only a claim under the Equal Protection Clause, and the courts would have had to adopt a map just like they did in 2012. That's what would have happened.
And at that point or a later point, could someone have compelled by mandamus the IRC process or no?
No, because that map would have been subject to the second sentence of 4E.
Thank you.
Thank you.
Good afternoon, Your Honors. May it please the Court, Timothy Hill for the respondents' appellants. In Harkenrider, this Court expressly, and I'm trying to move to an even more threshold issue than those that have already been covered, but in Harkenrider, this Court expressly held that a judicial remedy was exactly what the people had passed by the 2014 amendments. And yes, that is not the preferred method, but that is an explicitly contained part of those constitutional amendments.
But the main part of the constitutional amendment was this IRC process, to take politics out of it, wasn't it?
Yes, that was a goal. I think the goal was specifically to,
Was that the main goal, or you're saying judicially created maps was the main goal instead?
I think the main goal was to cabin in legislative overreach and abuse by a majority party that had too much control of the process.
So that was the purpose of the creation of the IRC as that vehicle?
Yes, and the constitutional amendments do that in two ways. Obviously, by making the IRC part of the process, albeit in a advisory role. They don't have final map-making authority, which is something that exists elsewhere in California or Arizona. And there was proposals for a constitutional amendment to make that the case in New York that were not approved by the people. The people approved these amendments that include the IRC as a component to inform that process for the purpose of reeling in those legislative overreaches.
Well, the legislative overreaches had been reeled in 2010 by the court, right? Because there were court-drawn maps and the favors maps. Is that also true for the several decades prior to that?
Yes, in the immediately prior decade, the Rodriguez versus
Yeah,
Pataki.
and the decade before that, and the decade before that?
Yes,
Going back to 1980?
yes.
Yeah.
There's
So is it conceivable to think that it wasn't simply a question of reining in the legislature, because the courts have been doing that for 40 years, that there was a desire to put in a process that was neither a judicial process nor a partisan process, but rather a bipartisan process that was the IRC?
Well, yes. I mean, the courts always had that function, and specifically the federal courts, because they might be called in to address equal protection.
Yeah, I mean, I guess to put a point on it a little bit, if the people had been satisfied with the courts reining in the high degree of partisanship and districting in New York, they wouldn't have bothered to pass the amendment.
But the amendments critically include the authority of the court in 4E. or a judicial remedy. And that's what this court held specifically.
I guess what I'm saying is if that's really what the people wanted, there was no need to include that because that's what had been going on for decades.
But not for the purposes of what's at issue here. As you've said, and as the Supreme Court has now had, the partisan gerrymandering is out of the federal court's hands. The issue of addressing partisanship and other abuses by the legislature is what is at the root of these amendments. And built into that process is the role of the judiciary. And it's a critical role. It may not be your first option, but it is the constitutional backstop that the amendment.
Yeah, but it is a limited, right? Is it not given let's stay with your language in 4E, since you're referring to it specifically, when it says, except to the extent that a court is required to order, it doesn't say to the extent that the court deems it necessary to order. I mean, it does have some limiting concept behind that particular word.
I agree that there is a limitation in that, but that is not a temporal limitation. That decision to decide whether.
Why not? Why can't it be?
Yeah, how do we know that?
Because the entire structure of these amendments is a sequential process. You go in order as they proceed. If there is, at this last phase, a defect that still warrants judicial intervention and remedy, that is, and so this court made the determination that that was required at the time it decided Harkenrider.
I guess what I'm asking, and I asked this before a different way, if Section 4E instead had said, redistricting the state except to order the adoption of or changes to, and that just continues to strike the words to the extent that a court is required, it seems to me that would mean the same thing that you're arguing now.
I don't think so, Your Honor. I think there has to be a determination by the court in the first instance on a case that's brought under 4E as
Well, but the rest of the sentence ends to remedy a violation of law. So it is a necessary condition that there has to be a violation of law. So I'm not sure what your reading seems to me to take those other words out of the statute.
The words to the extent required?
Yeah.
I think that means that the scope of the remedy at the time that it's issued is addressed to.
And why can't scope mean time?
Because the Constitution presents a situation where you're getting to a result that is a constitutional map that then goes into effect.
Well, doesn't the Constitution talk about time in the next sentence? I mean, that probably is the only temporal language in this where it says that the plan shall be enforced until the effective date of a plan based upon the subsequent decennial census. It appears to me that the only place that they are talking about time is in that sentence. Are we free to ignore that?
No, I think that's absolutely right. And I think the plan in the second sentence of 4E, there's no distinction between a legislative enacted plan or a judicial plan. If there is a plan as a product of a judicial remedy in the first sentence of 4E, that becomes a plan subject to the durational specifics of the
And what
sentence.
if that plan is, for whatever reason, erroneous? You agree that that can be modified, yes?
I'm sorry, I missed a word.
If the judicial plan, the plan that's developed through a judicial process, as opposed to the process in the Constitution that involves the independent commission and the legislature and the governor, if that plan has some error in it, you agree that it can be modified by the courts?
Yes.
That's the point of the last sentence in part of 4E, right?
Right, if that plan violated
So-
the VRA,
so-
you could have a.
So let's, for the moment, say that this court determines that the Harkenrider, the violation that Harkenrider was addressing, the remedy it came up with, was temporally limited. Okay, let's just say for one moment that we decide that that's went on. But we accept your view that the court could not have done that. The only maps the court can come up with are decennial maps. You with me?
I think so.
Okay. Would that then be a violation of the law that this court could remedy upon realizing the error of its ways?
Yes, but I think that would violate stare decisis. I don't think that this
Well,
court.
how is that? Stare decisis? How is that?
There's no reading of this court's very considered opinion in Harkenrider that does not involve the fact that it was the remedy for the then existing violations. And
No, I understand that's your position. My question was, assume for one moment we don't agree with you that that's the way you read Harkenrider, that we read it differently. But we agree with you that that might have been, that that is error. And all the court could have done is set up decennial maps based on this. Why can't we resolve that now?
I don't.
And resolve that by saying, now the IDC gets to do, the Independent Commission gets to do its constitutional duty.
I think this court or a court could remedy a plan that was implemented, such as what was ultimately implemented by the Steuben County Court. It wasn't appealed. If there was an error in that, and that could be the subject of a further judicial review. But I don't think this court can say that we made a mistake when we said what we said not a year ago. The fact that the IRC is not explicitly part of the judicial remedy that was the product of Harkenrider is not an error. There's no constitutional defect in the fact that the court-ordered plan doesn't have an IRC express, contribution to it. That is something that the petitioners have vacillated strongly on. There either is a challenge to the current plan or there isn't. And the fact that this court held, it's footnote 20, that the judicial remedy is exactly what is contained in the 2014 amendment.
Counsel, to get back to a question you were asked earlier, is the fact that the remedy that was made in Harkenrider doesn't include an IRC component to it mean that Harkenrider necessarily wasn't addressing an IRC error? Going back to that question about, whose error, what's the error that's being corrected by the court in Harkenrider? Does it preclude that possibility?
No, but I think as a practical matter, and again, in this sequential process that the Constitution lays out, the fact that the commingled sins of the IRC and the legislature, you had to address the one that came last because that's what put into effect on the books a map that people were going to vote on in the real world.
I'm sorry if I'm being difficult to understand. Would an error involving the IRC process necessarily require a remedy that also involves the IRC? Or was the remedy given in Harkenrider sufficient, even though it didn't involve the IRC, to correct what might have been a perceived IRC error? Does that make it any more clear?
Yes, I think I would fully agree that the remedy does not have to identically match what is perceived to be the violation. If the IRC didn't do something it was supposed to do, the remedy is not automatically, you must do that, particularly when there's a sequential process that's built into the Constitution and the time to do the thing
With
that's...
respect to Harkenrider, what was being remedied? Was it the IRC or the legislature's overreach?
It was the legislature's overreach and ultra vires act with them taking power that was not constitutionally conferred. But that was obviously intimately intertwined with the fact that they needed the IRC as a predicate to take that constitutional authority that they didn't have when they enacted that map.
Well, couldn't it be seen as there's a procedural error, the failure to follow the process as so set out in the Constitution, and then the substantive error, right? The claim that the maps that the state legislature came up with are gerrymandered in violation of the Constitution. And Harkenrider says we're not going to address the procedural error because that time passed in this moment, but we can address the substantive error, and that's the remedy we're going to come up with respect to substantive error.
I think that this court in Harkenrider clearly addressed both. It identified the procedural error, and it identify the substantive error in the
Could not Harkin Rider be read as, when it's addressing the substantive error, that it has a time limit on addressing that, because you can then resolve the procedural error down the road?
I don't see that, Your Honor.
It does seem to me that your answer to Judge Canataro's question about whether the remedy could address both the IRC failure and the statutory unconstitutionality is inconsistent with the argument that you're making about when the period begins to run for limitations purposes. Does it strike you that way or no?
I don't think so. I think the limitations argument is in that regard not merely a technical defect. It's substantive.
But I guess what I'm saying is if you think that the two are wrapped together enough that the remedy for what was only a violation, a constitutional violation through the statute, essentially the statute is unlawful, not anything where the IRC was a party or there was any attempt to get the IRC to do anything. If the remedy can reach both of those things, it seems to me then the converse of that is that the presence of the statute doesn't start the running until the statute is declared unlawful.
I would respectfully disagree with that. I don't think the incentive to bring a suit is what determines a statute of limitations accrual date. You can't say because we think that if this statute is upheld as constitutional, we have.
No, it's not. I'm not pointing to the incentive, but rather to the remedy. That is, if the scope of the remedy is broad enough to reach whatever injury might have come from the failure of the IRC to act, as well as whatever injury comes from the unconstitutionality of the statute, then that seems to me that it's not particularly appropriate to say that the limitations period runs from the moment the IRC couldn't act, because the remedy that the court is providing in the answer you gave to Judge Canataro encompasses both of those sets of claims. So
Yes.
essentially, it's not until that remedy is entered that there's the injury.
But that presumes that the action that's brought to accomplish that is somehow a hybrid that's both a mandamus proceeding and a invocation of the court's authority under 4E for judicial review. And that is something that is markedly absent from this pleading. This is only a mandamus pleading. It only asks the IRC to do an act. All of the petitioner's premises for how they would like 4E, both sentences as well as 5B, to be interpreted require that a court order an adoption or amendment or modification of an existing plan. The prayer for relief in this very limited special proceeding does not seek an order to modify or amend or adopt a redistricting plan. It only asks for a discrete act. So none of those provisions come in the way that they would like them to. This is not under the second sentence of 4B, the court order, the modified court order that sentence contemplates, is not something that this court can deliver. In fact, the proof of that is not only in the pleading and the prayer for relief there, but in the third department's decision, which granted them all the relief that they sought. And that decision is not an order modifying the existing plan. It's simply a direction to take one act. So the form of the pleading matters, and that's been fully ignored except for the last 2 pages of the governor's amicus brief that asks for some form of judicial rewriting of the pleadings, which at this late stage, and the fact that the petitioners themselves have not advanced that notion, I think is completely, ineffectual.
Thank you.
Thank you.
May it please the court, Aria Branch for the petitioner's respondents. The promise of the redistricting amendments has been deferred, but it need not be denied.
Let's talk about the redistricting amendment. It seems like we're putting process above substance here in a way, and talking about the redistricting commission as the be-all and end-all, and that's what the people were promised. But reading these amendments, it seems to me that the goal, the overarching goal of the constitutional amendments, and it's in section 4, was substantively to prevent gerrymandering. Districts shall not be drawn to discourage competition or for the purpose of favoring or disfavoring incumbents of, or other political candidates or political parties. And that particular provision, as I read it, maybe you disagree, applies to the IRC, doesn't it?
This court said in Harkenrider that procedural requirements matter because they help to safeguard substantive rights.
Right, they do, but we can't let the procedural safeguards trump the substantive rights, right? You would
don't
agree
trump the
that the goal here are fair maps, right?
The goal is for the congressional map to be drawn according to the process.
That's a procedural argument, but you're saying that trumps the substantive provision in the Constitution.
I'm not saying that trumps the substantive provision in the Constitution, but the procedural requirements are important. we
And they
know that-
failed last time, and we found they failed, and we put in place a process to draw maps, which, as I understand it, are not being challenged here.
We are not challenging the maps, but the remedy that was ordered in Harkenrider did not cure the procedural violation at issue in this case, which was the failure of the IRC to send a second map to the
And
legislature.
when did that failure happen?
That failure happened when the deadline passed.
And what day was that?
On February 28th, the IRC lost authority.
I don't think that's how I read that statute, because, or the provision. As I understand it, the first maps were returned to the IRC on the 10th of January, is that right?
That's correct.
And they had 15 days to submit second maps, right?
That's
So
correct.
that's January 25th to me.
The 15-day deadline passed on January 25th. The final outer constitutional deadline
I read
passed
that provision as saying if you have less than 15 days, then you get to the 28th maximum. Not that that's an outside deadline. So if they had sent the maps back February 20th, you would get the February 28th deadline as a hard stop.
I think that is one way to read the constitutional text, but this court did say in Harkenrider that February 28th was the outer constitutional deadline. The interveners in their brief.
We weren't interpreting that provision for purposes of a statute of limitations, right? It is an outside deadline. No, that's true.
And I think whether the deadline was January 25th or February 28th, at the time that both of those deadlines passed, the 2021 stopgap legislation was in place that allowed the maps to be drawn.
That's, to me, seems a separate issue, right? I mean, the IRC has failed to act. They have failed on January 25th to submit their second set of maps. That was their deadline. That was their obligation under the Constitution. They didn't do it, right?
At that time, though, the legislation cured the problem that we complained about.
It didn't cure the IRC problem. It didn't make what the IRC did okay. I mean, everybody in Harkenrider admitted the IRC had failed.
It allowed the maps to be drawn according to
Different
a
issue, though. You're not
process.
challenging that here. You're challenging the original failure of the IRC.
What we are challenging here is the failure of maps to be drawn according to the IRC legislative process that is set forth in the Constitution. That process was denied to petitioners, and it wasn't until the April 27th decision in Harkenrider when that legislation was declared unconstitutional.
And why,
but that
why
pro-
doesn't?
I'm sorry, go
latches-
ahead.
Why doesn't latches apply then?
Latches doesn't apply because this is a case where we are determining whether or not there was a final and binding determination. And this court said in Best Payphones that that happens when an actual and concrete injury has occurred that cannot be ameliorated by further action. The 2021 legislation ameliorated the injury that we complain of here.
You're
because it
confusing,
allowed-
I think you're confusing the nature of your mandamus petition because it's time, but it's type. So your mandamus is based on a failure to act. And I think you're confusing that with a mandamus challenging a decision, which we would review the things that you're talking about. But you're asking for action. So your timeline starts to run from the time of the failure to act.
The IRC never never refused to act in this.
The IRC on January 24th said we're not going to submit a second set of maps.
On January 24th, 5 commissioners, the Democratic commissioners, issued a press statement imploring their Republican colleagues to come back to the table to send a second set of maps.
Okay, but if that's not good enough, on January 25th, which was the actual 15-day deadline, they nevertheless failed to produce the second set of maps. My question is, what more do you need to know in terms of the failure that would bring about, that would trigger the mandamus time?
There was no refusal. What happened is...
I'm not saying there was a refusal. They did not produce the maps by the statutory deadline.
And that deadline passed, and courts have treated cases where an agency fails to act by its deadline as final and binding determination cases. This case, Bard College, was cited in Mr. Hill's reply brief. And when a court is determining whether a final and binding determination has been made, it matters when the injury occurs.
But go back to what Judge Garcia said. Instead of him repeating himself, I'll repeat. You're talking about something more in the nature of certiorari, that a final and binding adverse decision has been made. But this was, by all accounts, I think everyone agrees, a mandamus proceeding. It's in the nature of mandamus. And you knew that the agency that you were relying upon to do something wasn't going to do it, or didn't do it by the deadline that the Constitution provides for them to do it. It seems like your right is perfectly clear at that point.
At that time, there was legislation in place that allowed for the injury we complain of here to be ameliorated. But even if you treat this case as a refusal case, the statute 217 talks about refusals upon demand. And here there was no demand made by the petitioners. So I would suggest that the framework to use is the one that the dissent and the appellate division opinion used. We disagree with the way that they applied the framework, but the idea was that the petition in this case constituted the demand. That petition was filed on June 28th. Under laches, the question is whether or not the date that we filed that petition was reasonable. And it absolutely was. We filed the petition within 4 months of suffering the injury. And the 2021 legislation significantly ameliorated our injury because it allowed for completion of the process.
What would have happened if the IRC had submitted a second set of maps on February 1?
We don't know, right? I think that potentially it would have been okay because the February 28th outer constitutional deadline may have governed. I surmise that issue may have been litigated, but I think that given the priority that New Yorkers voted for IRC to send maps to the legislature, for there to be a process by which congressional districts would be drawn according to the IRC legislative process, that perhaps sending a map, slightly after the 15-day deadline, but before the February 28th outer constitutional deadline would have been acceptable because it still would have achieved the goals that New Yorkers voted for in the 2014.
Do you know of any law that bears on that one way or the other?
I'm sorry?
Do you know of any law that bears on that question one way or another? That is, if an agency has an interim deadline by which it's supposed to do something and a final deadline by which it must act, and it misses the first but makes the second, how that's treated?
I don't have a case to point you to, Your Honor, but I would suggest that the way that the redistricting amendments read, when you look at even the deadline for submitting the first map, right, there the constitutional text says that the IRC shall submit its first map on January 1st, but no later than January 15th. And no one has argued that submitting the map after January 1st was unconstitutional. So I think that the redistricting amendments contemplate that the IRC should act by the deadline set forth in the Constitution, but it has provided for outer deadlines.
What's the point of saying within 15 days? What's the point of that? Why not just have the February date?
I think, I'm not suggesting that the IRC shouldn't have acted by January 25th, but the idea is that if it didn't act by that point, potentially it could have acted by that outer constitutional
Then
deadline.
again, to Judge
And that's what-
Rivera's question, why have 15 days? Why not just say February 28th?
With respect, I think that's just how the amendments were drafted. I think
But they must
perhaps-
be drafted with some intent. The date doesn't come from anywhere, right? Why not say 12 days?
I think
Why not say
that-
20 days?
Sure.
It has to be, there's a reason why that language is there.
I think it was important probably to build flexibility into the process, right? The IRC, this is a new constitutional process. The IRC is made up of 10 commissioners. It's a bipartisan commission.
But I really
The idea
don't
would be to
understand
give them
that.
additional time to
They
reach
gave-
agreement.
They gave two deadlines. They gave a 15-day deadline, and then they said, but you can also have February or January? You could have it's February 28th. You could also have a February 28th deadline?
I think that is one way to read the amendments.
Wouldn't a more reasonable reading be more along the lines of what Judge Garcia said before, that it actually serves to give the legislature time to do what it needs to do? So if they were to reject a set of maps, that would leave not enough time to comply with the 15-day deadline. February 28th is absolutely the outer limit in that very specific scenario.
I think that is one way to read the amendments. But what I would suggest is whether it's January 25th or February 28th or a date prior to April 27th, the important thing for statute of limitations is when our injury occurred. Yes, the IRC failed to meet its deadline, but there was the stopgap legislation in place that was presumptively constitutional. We now know it was wrong.
The injury analysis goes to a different type of proceeding. Your mandamus proceeding is to get them to do something. You're confusing that, I believe, with a proceeding to challenge a decision. And that's when we look at what the injury is. But you are challenging a failure to act. You have a mandamus to compel. And you want them to do what they didn't do in January. So how long can you wait?
We brought this action because we are seeking the completion of the IRC.
Well, first, the maps that got promulgated failed, right? And then you brought this action.
The way to obtain completion of the process that New Yorkers voted for is to bring this
But
mandate.
New Yorkers voted for an anti-gerrymandering provision. That is, to me, the overarching statement of these amendments, that they don't want politically influenced maps to an extent that violates the substantive provision of the Constitution. This is a method to do that. The method failed. You now have maps that aren't challenged.
New Yorkers shouldn't have to wait 18 years from when they voted for the 2014
Well, they shouldn't
amendments.
have had to wait 10 either, but they,
The reality is that this court left unremedied in Harkin Rider a violation by the IRC. The IRC has never been held to account for its failure.
they
to
could
set
have been
set of
in
maps to the legislature.
for failing to act in January of 2022, right?
It's not clear that mandamus would have even lied at that point, because in order for mandamus to lie, the agency would have had to miss its deadline.
Well, I think our footnote in Harkenrider pretty much suggests it would, right?
If we had brought a mandamus action on January 24th, for instance, it's not clear that that would have been right, because there would have been additional time under the redistricting amendments for the IRC.
You didn't bring it on March 1.
You didn't bring it on February 3, where the ledge had given another set, basically neutering the IRC at that point.
Because at that time, maps had been drawn according to the IRC legislative process. The process that was in place, we know now, was pursuant to legislation that was wrong at that time.
But that wasn't an IRC
presumptively
process, right? I mean, you didn't get it, the people of the state of New York didn't get the benefit of their IRC procedure with those maps, but you didn't challenge them.
It allowed, that 2021 legislation allowed the maps to be drawn.
But they violated the provisions of the Constitution in terms of what the IRC was entitled to. They didn't adopt an IRC map.
But they allowed the maps to be drawn, and according to a process by which the legislature would have been the final arbiter on redistricting maps, which is precisely
But what you
the
said
redistricting
at the
amendments-
top of your argument is that you've come here to vindicate the IRC process, which is what was denied as a result of Harkenrider. the promulgation of the maps on February 3rd completely took the IRC out of the picture. So it seems as if you want to kind of have it both ways. Do you want the IRC process, or do you just want a set of maps that, you know, that complies or conforms to what you think the maps should be?
The petitioners want to live in districts that are drawn according to the IRC legislative process that they voted for.
But that didn't happen last time, and you didn't challenge it because you thought, okay, the legislature can do this. If the be-all and end-all really is the IRC, those maps weren't drawn by the IRC.
On February 3rd, the map was drawn by the legislature. That's correct. But it allowed the people's representatives, people who are democratically accountable to the people of the state of New York, to draw the map. The map was not drawn.
And we are, in a sense, also accountable to enforce the constitutional provisions. So I don't understand your point.
The 2021 legislation at the time was presumptively constitutional. We know now it was wrong, but at the time, the petitioners understood that maps were going to be drawn according to a process that allowed maps to be drawn by the legislature, by people that they elected. That was the
The official
promise.
process for doing this is also, as we decided in Harkenreiter, acknowledged by the Constitution. So what this court did in Harkenreiter, as we found in the majority decision, was authorized by the Constitution. So you have maps that have been drawn according to a constitutional process.
And we don't dispute that the maps are.
Same way you thought the legislature did it, right? You assumed the legislature's maps were constitutional because they had that statute. Well, these maps, which aren't challenged, are constitutional, and it's the process that we followed in adhering to the constitutional provisions.
The maps were not, the maps in Harkenreiter were drawn by a special master under emergency circumstances. They were put in place pursuant to Section 4E. They can be modified pursuant to court order, which is precisely what we seek here.
It could be modified. I mean, if they were challenged and it turned out the special master drew gerrymandered or racially unbalanced districts, they could be challenged and they could be amended by the court, I would assume.
They could, but they could also be amended to cure a procedural violation. The language in the Constitution states that the maps can be modified pursuant to court order and that the IRC shall be established to at any time that a court orders districts to be amended. It's not.
Can that be done in a mandamus proceeding?
This court told us in Harkenreiter that the way to resume the process, to get the IRC to act, was to file a mandamus proceeding. And it's undisputed that the IRC failed to undertake its constitutional duty to send a second set of maps to the
But bringing a mandamus to compel the IRC to do what it is required to do does not guarantee an acceptable map, a constitutionally acceptable map. You would still have a right to challenge the map that came out of that process, wherever it ended, whether it's with the IRC or some sort of subsequent legislative action. So it seems to me that the idea of challenging a map and the idea of bringing mandamus to vindicate a constitutional process are two entirely separate notions.
The map that comes out of the IRC process could certainly be challenged on substantive grounds, but the fact is the IRC did not complete its constitutional duty. And
then this court remedied that. I think you're just sort of skimming over that, but that's the real issue here. There has been a remedy dictated by this court in Harkenreiter. And I don't see a basis to overturn that remedy. We can't just say now, you're supposed to do Part A and Part B. That was violated. There's a remedy. But now let's go back and give them a chance to do B. Like, where else in our jurisprudence would we ever separate out these steps? The entirety of it holistically is a violation that this court remedied.
This court did not remedy the IRC's failure to send a second set of maps.
What
This
was the
court in
issue
Harkenreiter-
before the Harkenreiter court?
There were two issues before the Harkenreiter court. One is partisan gerrymandering, which is not at issue in this case. The other issue was the legislature's act outside of its constitutional authority. It
And is the
acted
court
without-
permitted to answer questions that were not before it at the time?
Yes, Your Honor. Harkenrider addressed a different procedural violation.
No, did you hear my question? Can the court answer questions that are not properly before it? Was the issue of whether or not the IRC properly acted in performance of its required duties, was that question specifically before the court?
It was not, Your Honor.
And are we allowed to answer questions that are not before us?
Your Honor, I don't think so. In that case, there was a claim made against the legislature. The IRC was not a party.
I don't see how you can say the IRC was not a party to that.
The IRC was not.
The IRC did not do what it was supposed to do, and that was the remedy that the court then, the subject matter is the same. I don't think you can parse out the IRC from the legislature. The violation is one violation, that their actions were extra constitutional.
Harkenrider addressed a different procedural violation, and it ordered a remedy that did not cure our injury. In Harkenrider, the issue was the legislature acting outside of its constitutional authority when it drew the map.
To borrow a question from the Chief Judge, isn't that inconsistent with your timeliness argument? If Harkenrider had nothing to do with the IRC and what they did or didn't do, why didn't you bring the mandamus when they didn't do it?
Because we weren't injured at that time. At that time.
That is a different mandamus. You're a mandamus to compel. That's a challenge to inaction, not what they did injured you.
Even if this is treated as mandamus to compel, and the IRC's failure.
Isn't that what you brought here, a mandamus to compel?
This action, it doesn't fit very neatly within either of the two mandamus frameworks. But I think that the court held in Bard College that when an agency misses its deadline, the question that the court asks is whether or not that missing of the deadline is a final and binding determination. And part of that inquiry from this court.
It's not a determination at all. It's a failure to act. And you're challenging a failure to act. They should have acted. They had a constitutional duty to act, shall language. And you're challenging their failure to act. You're not challenging their decision.
Even if this is treated as a failure to act refusal case.
But how is it not a failure to act?
Well, because the IRC never refused to act. The question is, it's a refusal, right? The statute of limitations occurs
But
when
they had an
a refusal is
obligation
made
to
upon
file a
demand.
new plan by a certain date. They didn't do it. They had a constitutional duty to do it. They failed to do it. So they don't have to refuse. They just have to do it.
Right. And the question is whether that failure to do it was final and binding. That's what the Bard College case says. But even if this
Final
is
and binding on who? I mean, it was a refusal to act, and you're challenging a refusal to act.
And the statute talks about a refusal upon the petitioner's demand. There was no demand filed.
You have waited
until
6
we
more
filed the
years and made that demand?
The question is whether when we filed our demand was reasonable under the laches framework. And that's the framework that the dissent and the appellate division applied.
Have we ever applied that as a court in this context? Have we ever applied latches rather than a straightforward statute of limitations from the time of inaction?
I think you have, in, for example, the Megan case, where the question was when was the demand made? And the demand was made when the petition was filed. And the question is, was the petition filed at a reasonable time? And we would submit it absolutely was, because it was filed within 4 months of our injury.
So, counsel, I see your red light is on. With the Chief Judge's permission, I just wanted to ask you if you could briefly address the argument that Harkenrider was not temporally limited to that upcoming election.
I think that pursuant to Section 4E, this court in Harkenrider provided a remedy to the extent it was required. It was required to provide that remedy because of the constraints of the electoral calendar in 2022. The election was already underway. That emergency has subsided. It is no longer.
Don't you think we would have had to have said that if we thought it was an interim remedy, we should have said so? Because at some point, we would have to give guidance to the electorate, to the citizenry of New York State about how to proceed once that 2022 election passed. And we didn't do that. I mean, do you find it odd that this high court would decide, you know what, let's leave this topic and leave the state unmoored so that they're at their own devices to figure out what happens after 2022?
We're not arguing that the map that was put in place in Harkenrider had an expiration date on it. It would remain in place had it not been, if it was not successfully challenged.
So we had to wait for this lawsuit to then clarify what we meant? And if it didn't happen, what?
That map is in place pursuant to 4E unless it's modified pursuant to court order, which is precisely what we seek here. I think one way to read what the court said in Harkenrider is that it was required to act under Section 4E in order to remedy the constitutional violation, the malapportionment injury that had occurred in that case. And that the court is no longer, that map is no longer required to be in place. It's not required to be in place for the remainder
You
of
can't
the
read only half of 4E. You have to read the rest of 4E that says, and now those maps are good for 10 years.
That's correct, unless they are modified pursuant to court order. And I would suggest that my friends on the other side read that language out of the Constitution. 4E doesn't say who has to modify the maps. You read the Constitution together. We have to read sections 5BA, 4E, and 5 together. 4E is silent on who modifies
But
the
isn't
map.
the way to modify that map to challenge that map?
That is one way to modify the map, absolutely. We haven't brought that challenge.
Your argument
because
is that mandamus to compel the IRC to produce a new map is another way to challenge the map that was produced as a result of Harkenrider?
This isn't a challenge to the map, but it still fits within the constitutional text, which allows the map to be modified pursuant to court order. It doesn't say that a court order has to modify the map. What happened based on the order issued by the appellate division is that it ordered that the IRC resume its duties, which would result in a map modified pursuant to that order. 4E doesn't say who has to do the modifying, but 5BA and 5 answer that question. 5BA says that the IRC shall be established to determine the district lines to remedy a violation of law. Section 5 says that the legislature shall have a full and reasonable opportunity to correct the law's legal infirmities. If you read the Constitution altogether, as we must, it's clear that the IRC and the legislature can draw maps at the beginning of the decade, but they can also draw maps to remedy violations of law.
Thank you.
Thank you, Your Honor.
Good afternoon, Your Honors. My name is Jessica Ring Amundsen, and I represent the chair of New York's Independent Redistricting Commission, Ken Jenkins, as well as Commissioners Cuevas Molina and Frazier. Your Honors, my clients are aligned with petitioners in this case because above all, they want to see that the citizens of New York receive what they voted for in 2014. As this court described what those 2014 amendments were meant to do, they were carefully crafted to guarantee that redistricting maps have their origin in
Why
the
is this
collective-
timely?
Your Honor, we have deferred to the petitioners in making their making their statute of limitations arguments, but we agree with the third department below that that it was when the legislation was declared unconstitutional. However, since we are technically respondents in this matter, we've deferred to the petitioners with respect to their statute of limitations arguments.
Would you agree that you were susceptible to a mandamus petition on or I'm sorry, not you, the IRC, on or about January 24th or possibly the 25th of 2022?
Certainly not January 24th, Your Honor, because all that happened on January 24th were dueling statements by various members
About
of
the
the
day
IRC.
after?
I agree. I actually agree with you, but what about January 25th?
On January 25th, the legislation was still in effect that allowed the legislature to take over. And it's important to remember that
Had you failed, had your group failed to perform their constitutional duty as of the 25th?
I don't believe so, Your
How,
Honor.
had you not? You had an obligation to file a plan in 15 days.
Within 15 days or by the outer limit of February
Well,
20.
we've been back and forth on that point, right?
Well,
How do we read that as then the 15 days doesn't really mean anything.
Well, Your Honor, I think if you look also at the constitutional text, it also asks that the IRC submit a plan by January 1st or by no later than January 15th. Certainly with the Board of Elections needing to establish election districts, earlier is better, but there has to be an outer deadline by which the IRC has to act.
So the 28th is essentially just a cutoff date if you have less than 15 days, is how I read that.
That's one way to read it. The other way to read it is February 28th is absolutely the date by which the Board of Elections needs to have information so
Well,
that,
the way I read it, though, actually gives meaning to the 15-day limit.
I'm sorry, Your
The
Honor?
way I read it gives some meaning to having a 15-day limit in addition to having the 28th. The way you want us to read it, I think, reads the 15 days out of the provision.
Your Honor, I think it encourages the IRC to act as soon as possible, given that time is of the essence in
So it's a
terms of getting-
suggestion.
but that February 28th is the outer limit. But in any event, the legislation was still in effect at that time that, and
But
I
it
think it's
seems the
important to clarify
crux
that-
of this argument, this mandamus petition, is to mandamus the IRC to act. And at that point, you failed to act. Now, we've heard a lot about the people wanting this process, that this process is really what these amendments were about. And at that point in time, on the 25th, the process, your group, failed. So
The process had broken down. However, the legislation at the time allowed the legislature to assume the responsibility of redistricting.
could that make up for the people not getting what they voted for in the Constitution?
Well, importantly, Your Honor, that same legislation also provided that the IRC should send over to the legislature, and in fact it did, all of the draft maps that were currently under consideration, so that the legislature would have them to act upon.
Did they act on the draft?
Responsibilities. Your Honor, the legislature enacted a new map on February 3rd. However, what is important here is what the voters voted for in 2014, which was a bipartisan, transparent process. The voters have not received the benefit of that guaranteed right with respect to their congressional districts.
Well, what the voters, we found, didn't receive last year, we found, was they didn't receive maps that complied with the substantive provisions of the Constitution that they implemented, saying you can't politically gerrymander the districts. That's, I think, was how this court interpreted that. So these other things are processes put in place to address that goal. The goal is to have fair maps that aren't gerrymandered.
The
And
goal
it
is to
seems
have-
like you're now saying the process is what's really the goal here, and the fact that we've now have unchallenged maps is not as important.
Your Honor, the goal is to have fair maps that are drawn through a transparent process by a group of New Yorkers who are selected based in consultation with community groups and with groups that protect minority rights. The goal is to have the process play out where those individuals travel the entire state, as these individuals did, at 24 public hearings, listening to thousands of people, so that people actually have a voice.
And we have a different obligation. It certainly is what's set out, and our constitutional obligations are somewhat different. And as we held in Harkenreiter, those are implicated by what happened here. So I think we all agree it's unfortunate when the court has to get involved in this type of dispute. But the court held last time that we did get involved, and that was specifically authorized by these same provisions of the Constitution with the goal of ensuring that maps weren't gerrymandered. And our process functioned that way.
I apologize for
No,
interrupting.
no, no, I think I interrupted you.
What the court did in Harkenreiter did not remedy the violation by the IRC, and we know that both procedurally and substantively. Procedurally, the IRC and its members were not before the court as respondents. The court did not have authority to order the IRC to do anything in its decision.
So are you
Substantively,
saying that until it was determined that the legislation was invalid, there was no duty for them to act, so there was no reason for you to bring mandamus?
that's correct, Your Honor. And
Because the IRC process had worked?
No, the IRC process had not worked. However, the legislation allowed the IRC's draft maps to be sent to the legislature, and the legislature.
By February 3rd at the latest, they rejected those, right?
Well, Your Honor, what's important here is that what the court did in Harkenrider, the IRC was not before the court, neither did the court's remedy actually address the problem here. How could the court address the failure of a transparent bipartisan process by ordering the
Agree, that
remedies to
should
send
have
it
been a
to special
mandamus
master?
proceeding to challenge that, the failure of the IRC process, and it was not a mandamus proceeding to challenge that before us. What was before us was making sure the maps complied with the substantive, procedural and substantive provisions of the Constitution, right?
Right, and what the court found was that the legislature acted without authorization and that the 2021 legislation was invalid. However,
Let me shift gears here a little bit for a second. If you want to complete your thought, go ahead, and then I'll jump
I was just going to say, however, that did not remedy the violation by the IRC, which again is what this court said in Harkenrider, these procedures protect substance.
So speaking of substance, which is exactly what I was going to ask you, would you agree that our decision in Harkenrider determined that the legislatively created districts were substantively unconstitutional?
Yes.
Yes. So were we, hypothetically, to say the IRC can now go forward, would you agree that it could not adopt those districts, let's start there,
Certainly.
and it couldn't adopt districts that were substantially like those districts?
Certainly, the IRC in acting would fully comply with.
It has to be constrained by the substantive holding that the districts drawn by the legislature the last time were not constitutional.
Right, and so the legislature, just as the IRC is bound by all of the provisions of the Constitution about competition and partisan gerrymandering.
Well, I'm not asking about those, I'm asking about by our decision.
By your decision, the legislature could not adopt the same map.
Or something substantially similar.
I believe that's correct, Your Honor, but the IRC certainly, and I think when my friend on the other side talks about an inevitable gerrymander, I think it's also important to look at what has happened with respect to the assembly map. Once the court ordered that the IRC undertake a redrawing of the assembly map, the IRC was able to do so in a bipartisan fashion. They submitted a map to the legislature on a vote of 9-1. The legislature adopted that map. The governor signed that map. No one has challenged that map. And so the IRC process, when it is allowed to play out and actually give the voters what they voted for in terms of a transparent bipartisan process, does work.
Has there ever been a challenge to the assembly maps, the oldest, no court has ever declared any assembly map unconstitutional, have they?
Your Honor, I'm simply saying that we have proof here that the IRC process works.
Let me ask you this. If we were to order the IRC to move forward, and the IRC broke down again, could we hold its members in contempt?
Your Honor, I think that the court potentially would have the power to enforce its order against the IRC. That has happened in other courts where members of commissions it has been at least contemplated to hold independent redistricting commission members in contempt for not fulfilling their duties. And in fact, in the Nichols litigation, the Supreme Court did retain jurisdiction when it remanded to the IRC in order to enforce its order if the remedial process wasn't followed.
Thank you.
If the court has no further questions, we ask that the lower court be affirmed, and we respectfully request that the court set a deadline for the submission of a second plan to the legislature. Thank you.
Good afternoon, Your Honors. Andrea Trento from the Office of the Attorney General, for the amici, the Attorney General, and the Governor. 2014, Your Honors, voters enshrined into the Constitution a process not only for drawing, but for remedying congressional district maps that centered on the work of an independent redistricting commission to develop proposals for consideration by the legislature. The The petitioners here are entitled to relief because the current congressional map, to the extent it is used in elections that go beyond, take place in 2024 and beyond, fails to conform to that process enacted by the voters and therefore must be remedied.
So to use that map in the next election, in your view, is a constitutional violation?
In our view, Your Honor, that map is defective.
No, answer my question now. Is it constitutionally defective?
It is constitutional.
So it would be an unconstitutional election in your view for that map to be used in 2024?
If that map is not remedied, that's
Remedied in what sense? So remedied in terms of giving the IRC another shot?
remedied in terms of adhering to the remedial process prescribed by the Constitution.
Which is something other than giving the IRC another shot?
No, it is, Your Honor. It's giving the IRC another shot, but giving the IRC another shot and giving the legislature as well its authority under Section 5 of Article 3 to remedy violations of law, and that happens through the IRC.
And where in the Constitution do you read this view that using that map is unconstitutional?
Because when this court in Harkenrider ordered that the Steuben County Court draw the map for use in the election in 2022, it had the authority only to the extent it was required to do that and to forego the requirements of Section 4, Section 5, and Section 5B. My colleagues refer to Section 4E as the first part of that first sentence referring to the IRC process, but then if something should go wrong, if the court needs to order a remedy as a result of a violation of law, then the second part of that sentence comes in.
So your view would be if we had said in Harkenrider that these maps are good until the next census, that would have been unconstitutional?
Your Honor, the map would not have been proper, yes. That's the answer.
So this court did not have the authority to do that under the Constitution?
That's correct. It was not required to prescribe a map for the duration of the remainder of the...
Can you imagine circumstances in which a court, not our court, but let's say a lower court, might have found as a factual matter that keeping let's say this map in place or that map in place for a decade was required?
Off the top of my head, no, Your Honor. The amendments contemplate that at any time, and this is referring to Section 5BA, and the point I wanted to make about Section 4E is the first part of Section 4E refers to states that the process for redistricting congressional and state legislative districts established by this section and Sections 5 and 5B of this article. Shorthand for that is potentially the IRC process, but Sections 5 and 5B also refer to a remedial process, and that's the remedial process that involves the IRC. 5BA says, at any time a court orders that congressional or state legislative districts be amended, an independent redistricting commission shall be established to determine the district lines. Section 5 says, in the event that a court finds a violation of law, the legislature shall have a full and reasonable opportunity to correct the law's legal infirmities. To the extent that those provisions can be upheld, can be observed by a court ordering a remedy, they must be.
So, counsel, if we agree with you and this goes back to the IRC process, I assume you agree that the IRC legislature are bound by the substantive anti-gerrymandering provisions. Yes? That new map, it's hypothetical, gets challenged and ultimately declared also in violation of the substantive, more procedural requirements. Could we use the other maps again? Would it be a constitutional violation at that point?
Well, it depends on what time in the election calendar that takes place. I think the body charged with remedying that constitutional violation would certainly have the option, I would suspect the option to go back to the original maps available to it, but it need not be the case. It would be up to the body then charged with remedying that violation.
So, yeah, courts. And then let's say we decide the remedy is that we're going to use the maps that we have now and it goes back, then we should send it back to the IRC again, and then they would do this again, and then it would be challenged, and depending on the timing, if it's constitutional or not, then we would decide if we're going to use those maps for the third time or not.
I understand where Your Honor is going with this parade of horribles that we're hearing here, but I think I would point, as my colleague did, to the experience the IRC had with drawing the assembly map.
That map was never challenged, right? I mean, the assembly maps were never an issue here. The Senate maps were, I think, but not the assembly, right?
Well, I think the point, Your Honor, is that even in the event of a challenge, the map may be upheld, and then that map would be the map for the rest of the decade. There would be
Would the obvious implication of that argument be that anytime there's a judicially created map that doesn't involve the necessary legislative IRC input, it would only be good for one election cycle? Is there a circumstance under which a judicially created map that doesn't include the legislature survives more than a year?
I do agree that under Section 4E, had that map in Harkin Rider that was created by Steuben County Court with the help of the special master, had that map not been challenged, then it would be the extant map for as long as it, until the next decade or until such time as somebody did bring a challenge to it, making the points that...
But your view is that map has been challenged?
That map has...
Vis-a-vis this proceeding?
These petitioners here are seeking via the same mechanism and the same relief that a petitioner would in challenging that map. And so I do think, and in page 282 of the record, their complaint, or their petition, amended petition, does reference defects in the court-drawn map, including the procedural fact that it wasn't drawn according to the process set forth in the Constitution.
So let's go back to the hypothetical about the seriatim challenges. Isn't there in that hypothetical, though, a built-in, I just want your view on this, a built-in disincentive? Because if the court is going to continue to step in and say that you violated the Constitution at some point, you're going to be reined in, which was my question to the other side. Aren't they incentivizing with their approach this IRC not complying with their constitutional duty? I mean, I'm finding it a little bit difficult to accept this argument when all it does is encourage the very behavior that they acknowledge is unconstitutional.
I think that's correct, Your Honor, and I appreciate that the Assembly map is maybe a different question than the congressional map, but we saw that play out with regard to the Assembly map. The Assembly map was a map that the IRC could not get together and submit a second version of to the legislature, but they did the time they were ordered by the court to do so. And so our view is that the same, well, who can predict, but I think there is a disciplining effect that a court order to convene and submit a map to the legislature could have.
I guess the question is how much discipline do you need, right?
Well, contempt seems to
have
have something.
At a certain point, the process itself, to me, seems to undermine what I believe is the overarching goal of these constitutional amendments, which is fair maps that aren't politically gerrymandered.
Well, Your Honor, I agree that that was one of the goals, but the process by which that one goal is to be achieved, there were more efficient ways for that process to be achieved. The voters could have been, what could have been proposed to the voters is just have the courts do it every time. That way there would be certainty that there would be no...
Nobody thinks, I mean, I've heard that, but nobody thinks that's a good idea. The courts are a fallback position provided for in the Constitution, as we've been discussing, and as we said in Harkin Rider, but it's kind of the, okay, this thing has now failed, and we're going to step in, and that's been going on for many, many years previous to this. I don't think it's realistic to say, well, we have written a constitutional provisions, the courts are going to draw them. That's really not our primary role here. It's as a check to enforce the provisions, and I think I'm hearing you say that the anti-gerrymandering or racially gerrymander, you can't politically gerrymander, those are just some goals. You wouldn't say those are on a par with the procedural sections.
Certainly to have a process that's transparent, a step removed from the political actors, but not totally disassociated from the political actors, and retain some accountability for the voters, I think was one of the goals of the of the amendments, but there are other substantive goals too. There's the anti-incumbency protections. There are the, communities of interest, and there are a whole series of goals that the amendments seek to enshrine into the Constitution.
Racial gerrymandering would be a goal, right? We agree that's prohibited by the Constitution, right?
Yes, Your Honor.
So you would agree, though, that that goal is more important than any process that we would put in place for transparency reasons, right? The ultimate goal is fair district.
The process is one way for the public to have transparency into, and for the legislative leaders to be accountable to the public in fulfilling those goals. And so I do think the
Are
process.
they mutually exclusive? Is it
not
mutually exclusive to have a robust process, whatever the electors decided, that ends up with a non-gerrymandered map?
They're not mutually exclusive. The process plays an important role, and the substantive requirements play an important role in furthering the goals of the amendments. And if I could, I see my time is up, but Your Honor had asked one of my colleagues, Chief Judge Wilson, about the source of law a potential source of law that would allow, or that would view an internal deadline versus a final deadline for an agency to act. And I think there is a pretty well-developed source of law that speaks to that, and that's the issue of directory versus mandatory duties, which this court has encountered. And when that arises is when time limits relating to the conduct of government business are imposed on officials or agencies. And the question for the courts to look at whether an internal deadline or a time limit within which an agency needs to act is a mandatory duty is whether it divests that body of jurisdiction over the matter. And the questioning did sort of touch on that issue, which was, had the IRC convened on the 30th of January, changed their mind and decided they could get this done, did they lack the jurisdiction to do that because of the passage of that January 25th deadline? And we would submit that they did not. That would have been something that would have gone forward.
The reason I asked is it seems to me that plays into the question of the availability of mandamus relief at that point, because unless there is a clear right to the mandamus, it doesn't lie.
That's correct, Your Honor. Under this doctrine, mandamus relief flows from the expiration of a mandatory duty, not a directory duty. Unless there are further questions. Thank you.
Your Honor, I had reserved 5 minutes, but I believe we went well beyond that, so I'm not sure how much time I have, but
We'll let you go until we get tired of you.
I do have three points to make. First, the question on statute of limitations is, when did it accrue? When could the lawsuit have been brought? Take yourselves back to January 25th, 2022.
Yes, but for a claim to accrue, to be able to bring a cause of action, you have to have the injury, which is where there is disagreement.
Right.
You're counting from the failure to act, and unless I've misunderstood her, they're counting from when one would say, now they've actually been harmed.
Yes, it's accrual. When accrual involves injury. I believe that if a lawsuit had been brought on January 25th, 2022 against the IRC on mandamus, there would have been 0 votes on this court to say that that was too premature. It would have been such a, I don't want to use frivolous, but it would have been close to a frivolous argument that no one would have made it, that you couldn't bring it on January 25th. So therefore, the 4 months started on January 25th. It expired in May 25th. They blew their deadline by...
Would we have had to decide whether or not the legislation, the stopgap legislation, was constitutional? In that proceeding that you're describing, the hypothetical proceeding you're describing?
Absolutely not, because the legislation is irrelevant if the constitutional obligation of the IRC is completed. If the IRC submits a second-round map, then the legislation is irrelevant. The legislation only purported to allow the legislature to act when that constitutionally required act by the IRC had not occurred. If that lawsuit had been brought timely, the IRC would have done its duty, and the legislation's constitutionality would have been an academic exercise. So it's clear to me that a politically neutral enforcement of the standard 4-month...
You're saying that statute is not tied to the deadline, it's tied to the act.
That's exactly right.
Right? Okay.
And further...
How long could the state have waited? How long could the state legislators have waited to figure out, it looks like they're really not going to act?
The 25th is the date in the Constitution. But even if Your Honors disagree with me, I think the statute has some import, then that just brings in the question of latches. You know,
Just before you get to latches, one thing occurred to me I wanted to ask you. Suppose that the 25th or the 26th of January filing was premature, but by the time a court could act on it, February 28th had rolled around. Is there any law about that?
No, but I do think that this court does have law that mandamus is an equitable proceeding. So if the lawsuit, if the proceeding had been brought in a time, the court would have all the equitable power.
No, I guess what I'm asking is if it had been brought prematurely, but it became not premature during the pendency of the petition, what's the effect there? Would we throw it out because it was brought too early, or would we say it's ripe now, even though it wasn't before?
I mean, maybe there would have been a dismissal for prematurity, and then it could, without prejudice, to refile. But I think that there wouldn't have even been. I mean, I know we're here, and you know, there's a political goal that's being achieved here, but I don't think that there would have even been an argument that you couldn't have brought it on the 25th. No one would have even imagined that argument. And
I guess what I'm asking is whether nobody would have imagined it because it would have, that argument, to whatever extent it had force, would have become moot by the time the court could have acted on it anyway.
No, because the IRC said it wasn't going to do it. Its deadline was here. Everyone would have said, yeah, this is the proceeding. This is the one that was referenced in footnote 10. But even if Your Honors disagree with that, at latest, under their theory of the legislation, which I still don't understand how it makes any sense, they should have brought their lawsuit in April. They waited 2 months. So we made an accusation in our papers. We said they waited 2 months because they wanted to see if the court-adopted map was going to be to the political favor. They didn't even dispute that. If laches is ever going to apply, it's when you have an accusation that you sat on your rights for a minimum 2 months, we think 5, for political expediency reasons. And then, only then, when you saw the map that you didn't like, then you sued. I understand there might be some unhappiness with that result, but we've got 4 statute of limitations, we've got latches that need to apply neutrally, politically neutrally, no matter who the party is, no matter whose ox is being gored. Second, you heard, haven't had much discussion of this today, but in order for them to prevail, they need to fit into what they're doing, into the word modify. There's just no linguistically possible way that this lawsuit, asking for a relaunch of the IRC legislative process, is a modification of the Steuben County map. It's just not. And then the final point I wanted to make is...
If we disagree with you on that, do you lose?
No, Your Honor, because then we still have our argument about untimeliness. We have our argument that a court-adopted map is not subject to modification just because it's a court-adopted map. There has to be some other reason. And then finally, the question of what was the main goal. Judge Trauman, you asked about that. The main goal was to avoid political gerrymandering. So the way it's done in the first instance is the IRC-driven process. If that fails, it goes to the court. Then the worst case scenario, the one that is completely out of bounds, is to have a mid-decade redistricting by the legislature, regardless of whether the IRC involved. That's a recipe for another festival of gerrymandering. And the most dangerous kind, when they know where the incumbents are. Chief Judge, they wouldn't do the same gerrymander. That wouldn't be the smart thing to do. They would see where the close Republican races were. They would target those individual congressmen in order to make those districts uncompetitive. We'd have another lawsuit, of course. And then either that lawsuit, if the lawsuit succeeds, then we'd have another fiasco. It's entirely unnecessary, Your Honors. If Your Honors really wants to come up with something that brings the IRC back in, which we think is completely out of bounds, past the statute of limitations.
But your explanation about what would happen really says that that the IRC process is never going to work, despite the fact that it's in the Constitution.
Not at all, Your Honor. The people determined in the second sentence of 4E that mid-decade redistricting.
No, I understand, but
So dangerous.
why would the motivation be different mid-districting than when the next decennial census comes up? I mean, you're essentially concluding that the IRC process may be coupled with if the legislature rejects it and modifies the map as allowed in the Constitution, is going to incentivize the majority party cherry-picking races, drawing the districts to destroy competition. And that may be true, but I don't see why it's truer mid-decade than at the end of a decade.
Certainly the people were aware of the possibility of gerrymandering, and they set out an IRC legislative process at the beginning with the judicial backstop. But the people did not want to have 2 rounds of this. Certainly we had a lot of problems.
They probably didn't want to have any rounds of it, but I guess what I'm still getting at is it really sounds to me as if you're saying the constitutional process is a failure, and it's going to fail no matter what time of year we're talking about.
Absolutely not, Your Honor. The way the people designed this is they thought there was a good chance that the IRC legislature process would succeed in the first round. However, they did create a judicial backstop. What they said is a red light, no way, is that to have a mid-decade redistricting. There is no provision in the Constitution that contemplates legislature's involvement in mid-decade. Judge Trump made referenced 5BA. That allows the IRC to be called back in and IRC. But that doesn't involve the legislature getting involved. That allows the court to call the IRC back in and said, there's a problem with this map. The IRC will come back in and tell the court, this is the map that you should adopt. Now, I think that there's no reason to have any of that here.
As I said, I asked you, I think, before, and if not, I'm asking you now. I understand you take a different position. Assume for the moment that we view it that there is no map because the maps had a temporal limitation. Can't then the court, under what your description of what the section provides for, can't the court then order the IRC? If someone comes in and says, we need a map,
If your honors take that approach and think there's a tabula rasa, then, and the honor needs a remedy, and they think there's some problem with the Steuben County map, which I think is very competitive and praised across the political spectrum, and wants the IRC involved. I think that then what should happen is the court should say, hey, IRC, under 5B, give a map to the court, and that will be the court. That will be the map. The worst case scenario, the absolute worst case scenario.
why would we do that?
Because 5B, the one that allows the calling back on the IRC, doesn't involve the legislature mid-decade at all. It involves the court and the IRC. And so what they've asked
Are
for,
we prohibited from doing that?
there is no provision in the Constitution that allows the legislature to get any involvement.
At all?
Past,
Even if the court orders it?
absolutely, Your Honor. The Constitution has only a certain time prescribed for the legislature to act, which is at the beginning of the process. If Your Honors think that all the maps are gone here and you want something to do with the IRC, the worst case scenario is to have the IRC to send it to the legislature, which, by the way, in this decennial has shown that it's not to be trusted, not only with everything that it did before Hockenreiter, but then after Hockenreiter, when it went to the Steuben County Court and said basically adopt the same gerrymander that the court rejected. And then afterwards, its leaders have badmouthed this court and said what this court did in Hockenreiter was political. There is nothing to show that legislature has learned its lesson and that it's not going to engage in a festival of gerrymandering if this court lets it rip. We think that they missed their deadline. We think it's unconstitutional what they're asking for here.
Yes,
If
but
Your
of
Honor
course,
wants-
if the IRC process complies with the Constitution, if we were to order that, and they didn't have to be held in contempt for that to happen, and then, as you say, the state legislature, the majority party, nevertheless draws maps that are gerrymandered, get a lawsuit. But you've taken out the procedural challenge, just have the substantive challenge. They take the risk that the court is going to say it's substantively a violation of the Constitution, right?
Yeah, they would take the risk, but they would be all upside for them because they'd either have the Hockenreiter map, which they have now, or they'd have their dream gerrymander map that takes out all those competitive
No, but the
seats.
court may very well order a remedy that they're not going to be happy with.
Well, they already know.
That's the risk.
I mean, I suppose there could be another special master, although I don't see why there would be another special master if we already have a perfectly good map that's the backstop to begin with. But again, nothing in the Constitution at all contemplates the legislature's involvement mid-decade. That's the most dangerous situation. Thank you, Your Honors.
Thank you.